if we're talking about international investment disputes which involve a state as one of the parties, what are the specifics in these areas?
Well, I mean, investment treaty arbitration is in a way, a special kind of arbitration. It's based on a treaty, i.e. public international law document, as opposed to contract, which means that the applicable law you're dealing with is public international law. And that requires certain skills and knowledge that you would otherwise not need to apply in commercial arbitration. So that's one important distinctive feature. The other one, of course, is that you're dealing with the state on the other side, which means that if I represent a claimant or an investor, usually it takes a lot longer for the state to act. I mean, to submit briefs to the tribunal, to appoint arbitrators, so on and so forth. That leads to investment arbitration usually taking longer time than commercial arbitration.
Ukrainian companies are now in the midst of several claims, several cases against Russia in connection with the annexation of Crimean Peninsula and the loss of businesses there. There is a claim by a wholly owned wholly owned bank or Shad Bank. There are private cases. How different are these cases from any other regular investment dispute? Because the circumstances surrounding these disputes are definitely very extraordinary.
No, that's true. I think, and that's probably the major difference, the factual circumstances. Because otherwise, we are still, as I said, we're dealing with public international law. And in those cases, the bottom line issue at the jurisdictional stage has been whether or not the investment protection treaty between Russia and the Ukraine is applicable at all. So as far as the legal principles are concerned, we're dealing with public international law. And the fact that the Russian Federation has occupied Crimea generates application of certain new rules and principles of public international law, which you don't see typically in other investment cases.
Again, if we go back to these investment disputes, would you say that following these disputes, there'll be some sort of new precedents set in international investment arbitration?
Yes and no. I think, as you may or may not know, there are now two decisions out there. I mean, two awards in which the tribunal has accepted jurisdiction because the Russian Federation has challenged jurisdiction, i.e. they've argued that the treaty is not applicable. And I'm involved in those two cases as counsel for the claimant. And what we have argued there, the issues that we've argued are new, I would say, in investment arbitration, but not necessarily new as far as public international law is concerned. But of course, the fact that this tribunal has now accepted jurisdiction will probably lead to more cases, that's my guess, against the Russian Federation. So yes, the yes and no, I mean, there are some new aspects, but generally we're still talking about application of public international law.
In case the tribunal finds in favor of Ukrainian companies, in your opinion, how difficult it would be for the Ukrainian companies to enforce these decisions?
Well, I think generally it will be difficult for two reasons. First is, I think one has to assume that the Russian Federation will challenge these awards. In these two cases, the place of arbitration is The Hague, so they will go to the Dutch courts and try to have this award set aside. So that's one obstacle. If they are unsuccessful, i.e. if the awards stand, you will have the next problem with enforcement, because I think one has to assume again that the Russian Federation will not pay up voluntarily, which means we, the claimants, will need to look for Russian state assets outside Russia to enforce against. And the Russian Federation, again, I assume, will rely on, among other things, the principle of state immunity. So in short, I think one can expect difficulties at the enforcement stage, unless, of course, the parties reach some sort of a settlement.
Do you see that settlement, amicable settlement of this dispute is realistic?
I think it's probably difficult. I mean, the end result of these cases will be a sum of money, assuming that we win. The Russian Federation will be ordered to pay a certain sum of money. And the settlement will be, in that case, about how much the Russian Federation is going to pay, again, assuming that we win. So when you're dealing only with money, it's usually easier to settle. In this case, of course, there are a number of complicated political aspects involved as well. So if the Russian Federation continues to view this as a, let's say, political case, I think it may be difficult to settle. But if they take the view that, okay, it's only, again, a sum of money, I think it's possible.